I think, I don't know what you're calling Mariette
2. The direction.
No. You know,
it's known as Mariette 2, sorry.
That
I think you understand what I'm saying.
That is Mariette 3, in my view.
Okay.
And there is Mariette 1, which is an excellent decision on joinder. On the interested parties, that is Mariette 1.
Okay, then I agree with you, then we can
and
go
then
to Mariette 3.
I think now there are 6. Mariette has now reached the 6.
Okay.
If you take into consideration Manyeso and Mangi Gishuki. I have been a criminal judge for quite some time, and we deal with criminal cases every other day. I will not say anything about the Mariotetus, whether they are number 1 or number 2 at this stage. But if you can remember when I was starting the interview, one of the qualities which I will bring is inter-court dialogue. And that inter-court dialogue will bring a conversation between the courts, especially the Supreme Court and the Court of Appeal and the High Court, and say, what is the effect on this decision? Because the you can get, if you want to know the impact of a decision, it is workability, it is application, and the way it is applied consistently or inconsistently, you only ask the magistrates and the judges who do criminal cases. We have a feedback as judges and magistrates on this Mariotetus. The AG was given an opportunity to solve this problem. It was not solved. The feedback is that there is issues. I can tell you, Commissioner Mariotetu, whether it is 1 or 2 or 3 or 4 or 5 or 6, it's one of the most misused and misunderstood decisions. And it is one of the most misapplied decisions. For example, recently when we were doing a criminal appeal, we had a case where 2 people were charged with murder. One was released on Mariotetu. The other one is before us. And when we asked, where's your colleague? We were told he was released by a magistrate. He made an application. The procedure we have in Nakuru, for example, is that all criminal appeals filed will appear before us for mention. And we had several cases where people were convicted for Sexual Offences Act under 8.1 or 8.2. And they come before us and say they were sentenced to life imprisonment by the magistrate. And then were given, when we mentioned their name, we were told by the prisons they were released by a judge. When? 2 weeks ago, 3 weeks ago, 1 month ago. And the matter is pending before the Court of Appeal. These are the conundrums and the tensions we are feeling. That's why I'm saying it is not in my place, for example, sitting here to say, this one, I think it should be done like this. This one should be done like this. But there is need for the Supreme Court and the Court of Appeal and the High Court judges to have a conversation or a dialogue on this misapplied, misunderstood jurisprudence from the Supreme Court, especially this Mariotetu. Those will be my answers. And I am only waiting for that opportunity to say, this is how it should be done. You see, the Supreme Court has no police to supervise how its decision is being used or misused. But if you give judges and magistrates some window, they can come up with a different interpretation. The question one should ask, for example, was this tension there before Mariotetu? The answer, I have no answer. Secondly, this is a precedent which has been set by the Supreme Court. it is the responsibility of the judges and magistrates to comply with that precedent or to follow that precedent. But I will add one thing, one caveat. Precedent is not an inexorable command. It is not. If there is a problem as a result of its workability, its application, the court can be invited to, or given an opportunity to say, this is the position people are, this is what people are doing with this judgment. Is there a way out? That's what I'm saying. We need an intercourt dialogue or conversation on Muretetu. Thank you very much.